do you mean you can't help me? Please, I have the money. There's got to be something you can do.
I'm sorry, miss. I would be breaking the law. Think about the baby's father.
He's not in the picture. Please, there must be some special circumstances.
The law states I can only medically intervene if your life is in immediate danger. You are in good health. I bet you could raise this child on your own, and if not, there's always adoption, right?
Right. Thank you, sir.
So, Miss McCorvey, I guess you've decided that you'd like to place your child for adoption?
Yes, ma'am, this is my last option. I can't raise this baby on my own, and I've already given 2 up for adoption. I tried to.
You tried to get an abortion?
Yes, I did. But I can't because of the law. No doctor will perform it.
I'm so sorry that all you've gone through. This is clearly not an easy decision. I'm here for you every step of the way, but after hearing your story, I cannot help but advise you to meet with 2 women that are friends of the agency. They're lawyers.
Lawyers? Why would they want to talk to me?
They're looking for plaintiffs to challenge the abortion law. I think you would make a good candidate.
I'll have to sleep on it. Can I have their contact information just in case?
Sure.
Good morning, Miss McCorvey. I'm Sarah Weddington.
And I'm Linda Coffey.
Please take a seat. I want to jump right into this. Miss McCorvey, I am so sorry for all that you have been through. I cannot even begin to imagine the decisions you have had to make and the difficult paths you have taken. My associate and I have been looking for women like you, women who feel that they should have control over their bodies, women who want a choice.
We hope that this lawsuit will grant more medical freedom to women within the state of Texas. You, of course, had the funds to get an abortion, but this is not necessarily the case for all women in the state. We want to not only give women a choice, but to make sure every woman has equal opportunities. I understand. My biggest concern is putting my name on this case. I don't want to be the face of this movement.
Absolutely. Miss McCorvey, we would never ask you to purposely put yourself in harm's way.
Are you familiar with the term pseudonym? No, I'm not. It's basically a fake name. See, you would assume the identity of Jane Roe. That's the name that will appear on all the court documents. Your name will never be uttered inside the courthouse. We will work hard to keep your identity a secret, because after all, our whole case is based on the right to privacy.
Miss McCorvey, if we use your story and apply our constitutional arguments and win, we may be able to change this law.
I can be your Jane Roe. Thank you, Miss McCorvey. We'll take it from here. Do you really think we can win this?
You have to have faith, Linda. Plus, we've got the law on our side. We've got the argument of personal privacy protected by the 1st, 4th, 5th, 9th, and 14th Amendments, and we've got the argument that the law itself is dangerously vague. The Doe's is a stretch. A married couple without children get an injunction to force District Attorney Wade from prosecuting women who have had abortions. It might be difficult to prove that the actions of the state enforcing the law are unconstitutional. Halford, on the other hand, has an easier case. A doctor facing criminal charges for performing abortions in a real and active plaintiff. As for us, if they rule in favor of women's rights to privacy, then there's a clear, justifiable controversy, and boom, we have grounds to sue.
I really hope this works, Sarah. Your Honor, these charges are ludicrous. Miss Weddington and Miss Coffey have brought me before here for simply doing my job.
Had Mr. Wade read our full argument, he would have known that we are also challenging the law itself, which we believe to be unconstitutional and dangerously vague.
I can't believe we lost. We shouldn't have lost. You said we were going to win.
She said we had a chance at winning, sweetheart. They're not the same thing. What's our next move?
Well, of course your case goes up for appeal. We'll go all the way to the Supreme Court if we have to. Fortunately for Halford, Miss Weddington, and myself, we were not only granted grounds to sue, but we won our case. Unfortunately, Wade is probably in his office right now drafting his appeal.
I don't think I can do this.
What are you talking about? Of course you can.
Well, look at what happened the first time around. I came in basically unprepared. Justice Potter Stewart told me point blank that I completely lacked the constitutional hook for my argument.
Sarah, you seem to forget that he criticized Jay Floyd's argument as well. They're giving you a second chance. We got the writ of certiorari and we're standing in the Supreme Court.
You're right, I can do this. Hopefully I'll be able to make it out to my car after recess before those pro-life protesters rip my head off.
We are ready to hear docket 70-18, Roe v. Wade. Ms. Weddington, you may proceed when ready.
Good morning. I'm standing here before you all because the women of the state of Texas still face a grave obstacle when it comes to their right to privacy. This problem that we face in Texas is that even though we were granted a declaratory judgment ruling the state of Texas abortion law unconstitutional, and even though we've been before this court once in the past, women still are not able to receive abortions from licensed doctors. This is because doctors still fear that they will be prosecuted under the statute. We are approaching this case from two angles. First, that women of the state of Texas should be able to receive abortions due to their right to privacy guaranteed by the 9th Amendment. And second, that the state cannot constitutionally prove that it has a state interest in the life of an unborn fetus. A case in Connecticut, Abel v. Markle, pointed out that no decision of the Supreme Court has ever permitted anyone's constitutional right to be directly abridged to protect a state interest, which is subject to such a variety of personal judgments. To oppose such a statute, the court said, would be to permit the state to impose its view of the nature of a fetus upon those who have the constitutional right to base an important decision in their personal lives upon a different view.
Tell me why you didn't discuss the Hippocratic Oath.
The Hippocratic Oath does not pertain to the constitutional protection we felt the women to have. It also does not pertain to the fact that the state had not established a compelling state interest. It is a guide for physicians, but the outstanding organizations of the medical profession have, in fact, adopted a position that says the doctor and the patient should be able to make the decision for themselves in this kind of situation. In this case, there has never been established that the fetus is a person or that it is entitled to the 14th Amendment rights or the protection of the Constitution. Here, we have a person, the woman, entitled to fundamental constitutional rights as opposed to the fetus prior to birth, where there is no establishment of any kind of federal constitutional rights.
Miss Weddington, your time is up.
Mr. Flowers, when you're ready.
Thank you, Your Honor. I would like to begin my argument by stating that the reason that the lower court found the statute unconstitutional was due to its vagueness and the fact that the court interpreted it to violate the woman's right to privacy. You see, what we have in front of us here is a balancing act. We must balance the rights of the fetus against the rights of the mother. Now, within the allocated time I have here today, I cannot even begin to describe the development of the fetus from the day of conception to the day of its birth. But what I can do is state the position of the state of Texas, which is that at conception we have here a human life, and that is protected under the 14th Amendment, which defines a citizen of the United States. Although there is no specific reference to an unborn child within the 14th Amendment, I believe that we must interpret it using what the framers had in mind at the time. And I use this to quote Mr. Joe Witherspoon, who has a brief here supporting our side of the case. He is a professor at the University of Texas, and he tried to trace back what the framers had in mind when they drafted the 14th Amendment. You see here, he quoted Blackstone, which was written in 1765, and he observed in his commentaries that, and I quote, "Life and this right is inherent by nature in every individual and exists before the child is born."
When you quote Blackstone, is it not true that in Blackstone's time, abortion was not a felony?
You're right, Your Honor. But you see, my point was to establish the thinking of the framers based on the general attitudes of the time and the people that they learned from prior to drafting the amendment.
Mr. Flowers, did Judge Campbell rely on medical authorities in his dissenting opinion in the Doe versus Scott
Yes,
case?
sir, and pardon me for using my binder. I just want to make sure I get this paraphrase correct. In summary, he stated that there is no distinction that can be made between prohibiting the use of contraception and prohibiting the destruction of fetal life, which, as explained above, may reasonably be construed to be human life. I find this assertion incredible. You see, contraception prevents the creation of life, and abortion destroys pre-existing life. In short, contraception and abortion are as distinguishable as thoughts and dreams are distinguishable from a reality.
My job as attorney for the state of Texas is to prove that the state has a citizenship interest in this case. We must assume for all intents and purposes that an unborn child whose mother lives in the state is a future resident of that state. It is for that reason that the state wholeheartedly believes that it has the right and the duty to intervene in cases of abortion. The state of Texas believes that because life begins at conception, that the fetus fits the definition of a citizen under the 14th Amendment. We recognize the moral and legal burden of the court. We understand that what we have here is a balancing act. No, we simply wish for the court to recognize the rights of the fetus.
Mr. Flowers, your time is up.
Thank you, Your Honor. Gentlemen, before we begin our vote, I would like to say a few words. After the vote is completed, we will begin drafting the majority opinion and any dissenting opinions of the court. What we have here before us will change history. The opinion of this court will forever impact the lives of every citizen of the United States. Abortion is a highly debated issue across the country. Now, let's begin our vote. I side with the petitioner, Jane Roe. There we have it. 7-2 in favor of the petitioner, Jane Roe. We will adjourn for the evening.
We forthwith acknowledge our awareness of the sensitive and emotional nature of the abortion controversy, of the vigorous opposing views even among physicians, and of the deep and seemingly absolute convictions that the subject inspires. It is the majority opinion of this court that the right of personal privacy guaranteed by the Ninth Amendment includes the abortion decision, but that this right is not unqualified and must be considered against important state interests and regulation. We do not concur with the petitioner that a woman should be permitted to terminate her pregnancy at any time during the pregnancy utilizing any method. The court believes that a state has the right to intervene in abortion proceedings to maintain medical standards and in the interest of protecting potential life. The court wishes to express that the right to privacy in the case of abortion is not absolute, and it must always have been considered with respect to state regulation. It is for this reason that the court has taken the time to present its opinions on procedures for each trimester of pregnancy. In the first trimester, the decision to pursue an abortion and the medical procedure is the sole medical judgment of the pregnant woman's attending physician. Throughout the first trimester, the state is permitted to act in the interest of the health of the mother and regulate the abortion procedure so that it favors maternal health. During the second and third trimesters, the state may act in the interest of potential human life and regulate and prohibit abortion, except in necessary cases in which to serve in the best